on, everybody? Welcome back to the Let's Talk Live podcast. It is September 29, 2023. We are so close to getting into October. I cannot believe how quickly this year flew by. I don't want to waste too much time tonight because I'm actually going to be streaming on another channel tonight. After this stream is over, I'll be over on the JJ Gentleman's Watch Hangout or JJ's Watch Hangout, talking a little Timepiece Gentleman tonight. So that show will be at 9:30. If you stick around here after this show, it'll connect you right over to that next show if you want to go watch me stream over there. So we're not going to waste too much time. What we have is the most recent pretrial hearing in the Karen Reed case. This was back on September 15th, so about 2 weeks ago. We're not going to waste too much time here. We're going to get right into it because it is a 2-hour hearing. So grab your popcorn, your favorite beverage. Let's sit back and listen to this pre-trial hearing. Here we go. The audio is actually pretty good on this.
For the Honorable First Justice Dudley Canoni, now sitting in the Norfolk Superior Court, and for the County of Norfolk. Draw the aid of your attendance, you shall be heard. I'll say the Commonwealth and this court. Thank you for listening session. You may be seated. Good morning, Your Honor.
Good morning.
This is the Commonwealth versus Karen Reed, docket number 22CR117. Can I have counsel identify themselves for the record, starting with the Commonwealth?
Adam Lally for the Commonwealth. Good
Good
morning.
morning, Mr. Lally.
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Good morning, Your Honor. Attorney David Unetti for Karen Reed.
Good morning, Mr. Unetti.
Good morning, Your Honor. Alan Jackson for Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little. Good morning, Ms. Reed. All right. So today was, originally it was just scheduled for status on the motion to compel. And you'll remember that last time I did ask you to put in writing exactly what was still outstanding and when you thought that you would get things, Mr. Lally, to the defense. So since, and we will do the motion to compel, but since that time, counsel have filed additional motions. So there have been, what I understand, what I have is 2 Rule 17 motions filed by the defense, one essentially for records from the Canton Town Clerk regarding the plow.
Nope.
Was that Zoom, Jim?
It was.
The second is a motion for the Google Nest of the homeowner here. 3 filed by the Commonwealth, footage regarding a motion for the video footage from the defendant's father's home. So whoever's on Zoom, you have to be muted or we'll throw everybody off.
I just don't understand how hard this is. They probably give you the rules and tell you, like, you're gonna come on, you need to mute yourself. I don't know why this is so hard. Like I sit through a lot of corporate meetings as well too, and it's unbelievable the amount of people that leave their microphone on during a meeting. Like, it's just general etiquette. When I ever go into a meeting room, I know there's gonna be plenty of corporate execs there. The first thing I do is mute my microphone going in. Like, how hard is that to remember? It's crazy.
Motion for records from ABC and NBC, essentially.
So unbelievable.
I think I can take care of it. Thank you.
Okay, thank you. And then there's a recent motion regarding exhaustive testing. Then there's a motion for me to review conditions of bail. And we're also going to set a scheduling order because these piecemeal Rule 17 motions coming in where an affidavit had been in possession of counsel since January 2022. We're not going to keep doing that. We'll set firm dates from here on. So before we start with the motion to compel, have the third-party record holders been given enough time? Have they been notified, Mr. Lally?
So yes, with respect to each of the respective 5 Rule 17s for both the Commonwealth and the defense, I did send notice to all the third-party subjects and all the third-party record holders.
Okay. Did you get any responses from anyone?
The only response I received, Your Honor, was from Attorney Gregory Henning, who represents Brian Albert in reference to the Google Nest situation.
Okay. Does he want to be heard?
I believe so, yes.
Okay. Is he here today?
My understanding is yes.
Oh, okay. Good morning, Mr. Henning. All right. So it makes sense then to start with the Rule 17 motions. Nothing from, were the record holders given enough time, Mr. Lally?
As it pertains to the Commonwealth's motions, yes, I did receive this latest one just late last week. So as soon as I received it, I sent notice. But so it's been at least approximately a week or so that they received notice.
Okay. Does the defense have any reason to believe that there are record holders who haven't been given enough time and you expect them to be in today?
Your Honor, with regard to it, let me just step up. That might be easier. Your Honor, if the court could define which of there's multiple motions, both from the side, the record holders from or with related to Mr. Lally's motions, NBC, ABC, alarm.com. Is that what the court's talking about?
I'm talking about all of them. Do you have any reason? Mr. Lally sent that he sent out notice to all of the record holders pursuant to Rule 17.
Right.
And that he only heard back from one person. I know some of these motions were filed late, so my concern was that some of these record holders did not get notice. Yes.
Just one addendum to that, Your Honor. I did also speak with counsel for the town of Canton, and they have no objection to the records, not
okay.
the Commonwealth, but I did speak to her as well.
Okay. Does that answer your question, Mr. Jackson?
Not completely. As it relates to the town clerk, no issue. As it relates to Google Nest and Google, we have no issue. As it relates to NBC and ABC, I have no issue with alarm.com, but the other two motions that the Commonwealth filed Rule 17 B motions on, I do have an issue with because I don't have enough information to be able to state with any authority that they have not received consumer notice. However, in speaking with both those entities, producers at both those entities.
Did you speak to legal counsel? Because that's where it went, right?
Correct.
I have not spoken directly to legal counsel on either side, but for either agency. However, I was told by individuals who had spoken to legal counsel that they had not been served. They had not received any formal paperwork from the Commonwealth as yet. And that was probably, I want to say, 5 days ago, something like that, 5 or 6 days ago. So that's the latest information I have. In other words, I don't have information that they haven't gotten notice, but I certainly don't have information that they have gotten notice either.
Mr. Lally, I don't want to continue this Rule 17 motion hearing, but what's the Commonwealth's position on that?
The Commonwealth's position is notice was sent at least 2 weeks in advance of the hearing date on those motions. I haven't heard anything from either of those parties. It was addressed attention to legal counsel for those entities. If the court wants to push it off to a further date for me to provide additional notice, I'm okay with that. But at the same time, I don't foresee being any issue. And obviously, if the court were to allow the motion and order the records and there was some objection to them, certainly no records would have to be produced until at such time as they could be heard.
All right. What I'd intend to do is go forward on the motion today. I will, in all likelihood, take it under advisement. And if we hear from them that they did not receive notice or they get late notice or they want to be heard, I can reopen it. So
that's satisfactory with us, Your Honor.
All right. So since you have, the one that seemed the quickest to resolve is the Canton Town Clerk motion. Mr. Clerk, that's paper 116.
Thank you, Your Honor.
So in reviewing that, I sort of assumed it was something that the parties might agree to, and you say the Commonwealth agrees to that, Mr. Lally?
No objection, Your Honor, no.
Okay. All right, so I will allow that. I'll take a closer look at the proposed order. That motion will be allowed. All right, Mr. Clerk, I'm going to hold on to that to take a close look at the order. All right, so 116, and now we'll go to the Google Nest motion, Rule 17 motion, paper number 125. Mr. Henning, why don't you come up since this affects your client as the third party. Okay. So why don't I hear first? I just like you up here. Why don't I hear first from Mr. Jackson? Sorry if it makes it uncomfortable for you standing there. Why don't I hear? I guess you'll have to take a seat. Why don't you just sit back? Thank you. I'm sorry, Mr. Henning. All right, Mr. Jackson, I'll hear you on your motion.
Thank you, Your Honor. There's very little question that the security camera footage capturing the interior and exterior of the Albert home, the scene of John O'Keefe's death, is evidentiary, it's relevant, it's material to the defense, and it should be material to the prosecution, I would think. It should be
I
material.
have a proposed order from the Commonwealth, so I don't know that there is that much of an opposition to
There may
this.
not be, but there may be an opposition from, sounds like Mr. Henning has some things to say as well, and so my comments are directed as much to that as it is to the Commonwealth. We've known for some time that there was a camera at the house of the Alberts, but what's truly interesting is how we know that there was a camera at the house of the Alberts on the date that John O'Keefe was killed. We know that there was a camera at the house, Your Honor, because a grand juror asked Brian Albert during the course of his testimony about the camera. It wasn't the Commonwealth that asked that question. The assistant district attorney went through 26 pages of questioning at the grand jury, a full panoply of questions surrounding the circumstances of John O'Keefe's death on January 29th, 2022, and not a single question was asked about security footage that did or did not exist at the time.
There's also a camera at 31 Fairview right across the street that literally would have that full location. I was just there the other day. I showed you the camera on my live when I walked the neighborhood. And I think that's a police officer's house. There's a camera right there on the front door that would show that whole view of 34 Fairview Road. It would show everything that happened that night. And for why that camera footage was never turned over or asked for, I don't understand. So this is what I mean. There is a lot of weird shit in this case. And that's why I said, I think that if I was on the jury right now in this case, hearing what I've heard and read through already and the arguments on the defense side, there's no way I could convict Karen Reed. I have way too much reasonable doubt. Way too much reasonable doubt.
Grand juror had to step in and ask that question. And that's interesting in and of itself, but
yeah, I just walked by that house the other day, Olivia, on my live, and I zoomed in right on the camera that's above that, right there in the front door of the house. It has the full view of the street. Full view of the street. Why was that camera footage never turned over or asked for? Or maybe I'm missing something here. It doesn't make sense. It would show legitimately 31 Fairview would show the entire crime or the whole scene. So you're either going to get the crime or what really happened. You're going to get the crime or you're going to get John walking into that house. It would show everything. It would show everything. All right, let's keep playing this.
this is a longtime law enforcement officer, Brian Albert.
I'm actually going to interrupt you. Mr. Lally, is there any objection from the Commonwealth?
So as it pertains to the motion being allowed, no. The only objection, and that's why the Commonwealth filed a modified proposed order, because it's seeking records from Google.
Okay, so we'll talk about the proposed order. Before I hear you, because we have so much to do this morning,
Unbelievable,
Mr. Jackson, I do want to hear whether Mr. Henning is objecting to this. Come to a microphone, please, on behalf of his client. It will save us some time if we direct it to the order if there's no
I
objection.
do understand. I don't think my comments are going to be very lengthy, but there are some things that I do want to put on the record on behalf of Ms. Reed.
Okay, I'm
as
going to
it
ask you to
pertains
have a
this.
seat. I'll hear if there's an objection, and then you can figure out what you need to say if there's no objection.
I can't believe that, Kelly. Karen Reed has been up front. She's been vocal. She's been out talking. She's talked to almost every media outlet out there. So let's just compare apples to apples. Brian Koberger hasn't said shit. Okay. Brian Koberger has only spoke to his attorney saying, I was just driving around. Karen Reed has gone on record and said, I haven't done any of this. She's been out there. She's given an alibi or her version of the events. So if you want to compare apples to apples, it's just, I don't see it. I don't see it. The biggest thing is Mary, one of my channel moderators, I don't know if she's in the room right now, but she made actually a good point. She said, you look at the PCA, everybody saw everything else, but no one knows where John was at that time. No one said they don't know where John was. Read the PCA. It's almost like they're plucking out all of the pieces of all the eyewitnesses that were there, and they're all just saying, nope, they never mentioned anything of John. Don't know where he was, never saw him. Ryan Nagel drove right by the SUV, looked over at Karen Reed's SUV, said the interior light was on, looked at her sitting in the driver's seat at 10 and 2, never mentioned anything about seeing a male, not inside the car, outside the car. So everybody knew at that point, all the witnesses knew that John was there. Where's John? Where is he? Is he walking up the neighborhood? He's in the backyard hanging out, or is he in the house? So to me, it's really weird. I'm not upset at all. I'm not upset at all. Completely not upset. But this doesn't make sense to me. There's a lot of things that don't add up in here. Explain the scratch marks on his arm, the bite marks. I mean, listen, it doesn't make sense to me. It doesn't make sense at all. The 62 feet at 30-degree elevation, snow on the ground, that she got up to 24 miles an hour, impossible. Turtle Boy was out there, measured 62 feet out, backed up on a clear day, clear skies, nothing obstructing on the ground. He couldn't even hit 19 miles per hour. That road curves. He went on a curb. And he's been down there a bunch of times and drove backwards and said, I didn't even realize the road curved there. You can see the curvature of the road. Doesn't make any sense. A lot of stuff doesn't make sense. A lot of stuff doesn't make sense.
On behalf of the homeowner.
Well, I'm not upset at all.
Order that the Commonwealth
but if there's something going on,
Mr. Albert, the homeowner has no objection to the Rule 7.
Thank you. All right, I'll hear you now, Mr. Jackson.
Prosecution's not turning over evidence. They have the swabs of John O'Keefe's arms on those scratches, or those abrasions is what they call it. If those swabs would be turned over and they swab though, if John was bit by the dog or scratched by the dog, there would be dog DNA on that. Why aren't they turning over that evidence? Why haven't they given it to defense counsel yet for testing? Doesn't make any sense.
I don't know if you heard that. Did you hear Mr. Henning?
I think I heard him say that there's no objection.
To the proposed order from the Commonwealth.
The proposed order that
I mean, right now, like I said, I went on record last night, and there's going to be no one to convince me otherwise unless I have some damning evidence in front of me. But right now, if I was on that jury, I definitely would say that there's so much reasonable doubt right now. So much reasonable doubt. I don't know who did it. Was it someone in the house? Was it someone in the neighborhood? Did he get hit by a plow? I don't know. But I'm saying too much reasonable doubt. Way too much reasonable doubt. And the thing that's really weird about it is, like I was saying, everybody seems to see everything else that went on that night, but doesn't know anywhere where John was that night or what happened to John. Didn't see anything happen to him. Didn't know where he was, but everybody saw everything else. Doesn't make any sense.
problem with the proposed order.
Someone had to have seen
indicates that they believe that the information is appropriate prior to January 29th, which is in and of itself ridiculous.
And
the whole point is to get the camera footage from the 29th,
Google search,
early morning hours of the 29th.
How long to die in cold?
Again,
27 a.m. in the morning.
This has become a sort of a theme with the Commonwealth. They indicated they wanted to change the proposed order and literally put in the proposed order that any camera footage that we would get would stop at midnight on the 28th. We have to have the footage from the 29th. And I question whether or not that was as the Commonwealth.
Did you see number 3 of their proposed order?
Proposed order is.
I read it as it's asking for a longer period of time than you requested. It's more expansive than what you requested, Mr. Jackson.
Number one says activation or setup information for any Google Nest camera registered to Brian Albert or Nicole Albert prior to January 29th.
Right, that's one. Number three. The Commonwealth's proposed order is more expansive than the defendant's proposed order. If there's an objection to that, I'll hear you.
But obviously, there was no objection to us expanding the time. We wanted it as expansive as possible.
I just want to make sure you have the motion. Do you only have the first page of it?
No, I've got the motion. The motion was supplied to us, again, this is the second time this has happened, when I was on a flight yesterday.
Mr. Yannetti, did you receive this?
Yes, Your Honor. We both received it. I mean, I can read it on my phone as well as I can read it on the on a piece of paper. My issue is, as I indicated, I want to make sure that the proposed order extends to the early morning hours going through January 29th. As long as it does, then obviously we're on the same page, and I have no issue with the Commonwealth's proposed order. I want to make sure that, and I don't have any issue with the Commonwealth's proposed order as it relates to other Google apps, for lack of a better phrase. The activity apps, financial apps, things of that nature. That's not what we're interested in. We're interested in Google Nest data. So as long as that proposed order includes and encompasses January 29th, then we have no objection, obviously.
Mr. Lally, am I reading this wrong?
No, Your Honor. Actually, number one that Mr. Jackson was taking issue with is actually directly copied from his own proposed order. Number three is, as the court noted, a more expansive time frame that goes up until 8 p.m. because if there were to be video footage, the Commonwealth would be seeking that to expand beyond the police response and everything else that's been taken issue with over the course of this case. So the only differences between the Commonwealth's proposed order and the defendant's proposed order is, number one, excising any sort of other Google account information. Which
And I think Mr. Jackson
relevant.
just said he didn't have an objection to that. All
That
right.
and expanding the time frame.
Okay.
The only wording that was changed under number one that we have an issue with is again, we believe it shouldn't be prior to, but inclusive of January 29th, any setup inclusive of January 29th, as well as the end of that same paragraph that indicates that the request is for information from any on-site activation by the residential user and not an activation that might occur at point of sale. There is no such thing as point of sale to our knowledge of a Google Nest activation system. In other words, the setup, I think that's a throwaway line, and I think it should be stricken from the order because it's confusing. There is no point of sale activation that we're aware of for Google Nest systems. But other than that, that's relatively pro forma. Sum and substance is that we get the Google Nest data. That's what we're concerned with.
All right. And you'd prefer that I add the expansive time frame than the
Correct.
less restricted time frame
Correct.
that you requested?
Yes.
All right, so Mr. Clerk, you can mark this. I'm going to hold on to it because I'm going to take a look at the orders more closely, but Rule 17 is allowed, no objection from the homeowner. So thank you for coming in for that, Mr. Henning. All right, so now we'll do the Commonwealth's, the motion for the alarm. Is there an objection to that, Mr. Jackson or Mr. Yannetti or Ms. Little?
Not from the defense.
Okay. So this is the Commonwealth's motion for records alarm 121. Did you propose an order with this, Mr. Lally or Ms. McLaughlin? Did you propose an order that maybe I don't have?
Should be an order attached. I can provide the copy with an additional.
You might have it, Jim. All right. Thank you. Thank you. All right, so Jim, I can give you back that whole motion. All right, I'll hear the Commonwealth. Do you want to start with, I have first the ABC News one. Why don't I hear you on that?
Just, it makes no difference to myself, Your Honor, but there's also another related motion to that camera.
Which is to the camera one?
Yes, from the House indictment. It's a motion to compel, to preserve, and request for order production.
I don't believe I have that. When was that filed?
Same time as all of the others.
It could, I mean, I just have copies, so it could be that it was that. So Jim, it's probably somewhere around 121, maybe 123. Is there an objection to this from the defense?
No.
Thank you.
You know, the way that I try to look at this, and I'm trying to get through this as quick as I can, but the way that I try to look at it is I don't look at it in the sense of, I try to take the law enforcement angle out of it. I just say, what if this was a group of friends in the house? Okay. Because I think people get really skeevy or sketchy about that, about like, oh, you know, it possibly could be a law enforcement cover up or a corruption, allegedly. You know, that is the reality of this. And things like that do happen. But I've always said 100% I back the blue here. Absolutely. But if there's something, you know, if there's something going on here, then people need to be investigated. People need to be looked into. And just for myself, like I said, over the last week of doing a really deep dive into this and seeing both sides of the stories and reading into stuff and learning more about it, if I was a juror on this case right now, I would have tons of reasonable doubt. I wouldn't be able to convict her. I would be that one juror probably in that room, or maybe there'd be a few other people with me, but I definitely could not convict her. I couldn't do it. I don't have anything in here that's hardcore concrete right now. Everything seems very wishy-washy. I think she's going to get off. I think if this goes to trial, she's going to get off. I do. I think it's going to create a ton of reasonable doubt in that jury.
All right, Jim. All right, so why don't I hear you? It doesn't matter to me whether it's ABC or NBC that you want to start with.
Your Honor, I think we can take them sort of in tandem.
I mean, even when they had video of her and John inside Waterfall, I think it was Waterfall. It was Waterfall. They were hugging at the bar. She was kissing him on the cheek. It didn't even look like they were in any type of anger or nothing. Everybody was having a good time that night in the bar. So it doesn't seem like there's any like precursor to it that, you know, they looked like they were fighting, they were mad. None of that was portrayed in any of the video leading up to this, that her and him were together. It's just it's odd.
It's essentially the same issue, the same type of factual background. Essentially, what the Commonwealth is requesting is any and all video footage, including raw or unused or unaired video footage of interviews, specifically with the defendant herself. She submitted herself to interviews with multiple news programs. The content of those interviews was sort of interwoven within a narrative story, which the Commonwealth would submit as a fair inference if there's additional footage that is available. In specific reference to the NBC, there's an indication from the broadcast that this is part of a larger program to air at a future date. These statements by the defendant, as the court is well aware, are entirely admissible. They were freely given by the defendant in each of the respective news broadcasts. The defendant, at least in part, so some of the statements she's on her own along with the reporter, and some of the other statements she's seated at a table with counsel. So as it pertains to any of those statements, there's an exception to the hearsay rule as far as statements by a party opponent. Any statements that she makes to these outlets, she's free to make, but the Commonwealth is seeking production of those statements.
Okay, who am I going to hear from the defense?
Your Honor, at this point, we don't have an objection objection to Rule 17, I think you're, I know there's going to be.
Speak into the microphone.
Sorry. Thinking that microphone's going to pick us up. I
It will, just be closer to it.
Sorry about that. We don't have a principled objection to the Rule 17 because it's really not our dog in the fight, as it were. In terms of ABC and NBC, if the subpoenas issue, I have every reason to believe that both NBC and ABC's legal department will take great issue with the subpoena for reasons of their own. But the defense is not taking a position on the Rule 17 at this point because it's not our fight.
Okay. All right. So do you want the opportunity to speak to legal counsel and see why they weren't represented here today, Mr. Jackson?
I would like that opportunity. It is unusual, I think. I suspect that there may have been, and I don't want to speak for the Commonwealth, they know better than we do. Both NBC and ABC are out of state. I don't know that they were served out of state.
Of course.
Right?
I think the Commonwealth, yes, they're served. It's
sure.
right in the pleadings.
But I'm not sure where they serve notice. I just don't know, because when I did check, both legal counsel, both offices, general counsel for NBC and ABC indicated to me through another person that works there that they had not gotten any information concerning this issue. So I would like an opportunity to check with legal counsel.
Okay. So I will.
She does have an interest in it.
I will take the motion under advisement.
What happened?
If they want to be heard, I will give you 1 week for
Turtle
them
boy
to give notice to this court by way of letter of legal counsel as to why they did not appear here today. And then we can see about
Yeah, he
setting up
needs
a
to be
hearing.
seen on my show.
And,
That's what he
if
needs.
your
to do.
position
He needs
is
to
that
get on
you don't
my
object
show.
to it and it's just with them, we'll set a date.
Thank you.
Where are you, Turtle Boy?
All right,
We
so
were
I'll do
so
the same with
close. I
both of
was
those motions.
that close to getting everything wrapped up, and you disappeared on me.
Why don't we do the motion to compel, and then we'll get into the
Shout out to
exhaustive
Turtle Boy.
testing
Get on my
motion.
show.
Is there an objection to the
Let's do
exhaustive
this.
testing motion?
I want to hear it all.
At this point, Your Honor, there is.
Okay, so we'll
there's
hear
some
the
technical
motion.
reasons, but
We'll do the motion to compel first.
thank you.
And so when this motion was first filed, and I do appreciate, Ms. Little, that you did get it to me in a timely manner after the last hearing. I do appreciate that. And I appreciate the detail of it. So then we have the Commonwealth's response that then maybe limits some of what you have there. And then I've got your response
Thanks, Hope.
to the
Appreciate you.
Commonwealth's opposition. So I think that's where we have you focused. But has that changed at all since you filed this? I received additional statements of compliance by the Commonwealth.
I will address those today, Your Honor. There's 5 sort of outstanding categories of evidence that we still have not received. I did receive a packet of information today, but I'll go through that for the court.
Okay, go ahead. So let's do what you address in your report.
I mean, I look at it this way, I've been kind of comparing this to the Idaho case, the attorneys. If you even want to go there and talk about like Ann Taylor versus this defense team, this is a powerhouse team. Ann Taylor couldn't even shake a stick at this team.
Bye.
Thank you, Your Honor.
She couldn't
It
even
has
in the
now
same
been
room.
a year and a half since Ms. Reed was arraigned in Norfolk Superior Court. A year and a half, and the defense still has not been allowed to so much as look at the physical evidence that the Commonwealth has had in its possession for 21 months and has so desperately withheld from the defense out of fear of what it might show. That is unacceptable, that is unconstitutional, and that clearly violates the mandatory discovery provisions set forth in Rule 14. As I informed the court, there are 5 categories of mandatory discovery that continue to be withheld by the Commonwealth, and I'd like to go through those in turn. There are first 56 items of physical evidence that we have been unable to view, unable to independently test.
Are these the items that are at the lab for testing still?
That's correct, Your Honor. It includes all of the taillight pieces, all of Mr. O'Keefe's clothing, and all samples taken from Mr. O'Keefe's clothing and person. This is the seminal evidence in this case. Your Honor, this is not a complex legal issue. The United States Constitution, the Massachusetts Declaration of Rights, and Rule 14 all require that Ms. Reed be permitted to inspect and independently test this evidence. Rule 14 could not be more clear. Quote, the prosecution shall disclose to the defense and permit the defense to discover, inspect, and copy material and relevant tangible objects at or prior to the pretrial conference. Our first pretrial conference was on August 12, 2022. The compliance date for mandatory defense access to this physical evidence was more than a year ago. In opposing this motion, as Your Honor noted, the Commonwealth has tried to excuse its blatant discovery violations by claiming lab protocols and procedures simply won't allow us to access this evidence. But lab protocols and procedures are of no legal moment, Your Honor. They don't trump the law. In fact, Rule 14 actually contemplated that this might be an excuse that the Commonwealth gave. It specifically says it doesn't matter if the physical evidence is not in the physical, actual, tangible possession of the Commonwealth. If that evidence is in the possession of any agency who participated in investigating and evaluating the case and reports to the prosecutor, which clearly the Massachusetts State Police Lab does, then discovery is mandatory. That's Rule 14. As this court well knows, this is not the first time we've requested access to the physical evidence in this case. So when Mr. Lally stands up, as I believe he probably will, and says, we're almost done testing, the defense can have access to this in 30 days, I want to remind this court that we've been here before. In fact, we argued this exact same issue before the court 6 months ago. And I think it's important for the court to be reminded of the representations that were made by Mr. Lally at that hearing. On February 8th of this year, Mr. Lally stood here in open court and made these promises. Quote, I did speak with the lab earlier this week, as well as last week, a couple of weeks ago, and on several different occasions. But my expectation from what I'm told is that their analysis and report should be complete within the next 30 to 60 days. Those were Mr. Lally's words in February. And my guess is that's what he's going to say today. But what is disturbing about those representations is that the crime lab actually keeps track of their communications with Mr. Lally. And when you review the crime lab conversation log, which was produced to us in discovery about a month ago, this is what you see. Quote, note to file, date January 3rd, 2023. Entry by John Buello. Person contacted, ADA Lally. Note, quote, emailed Commonwealth prosecutor on 11/21/2022 about the status of testing. No response back. Therefore, the trace items will not be tested at this time. If for any reason testing is needed, the items can be resubmitted to the lab for potential analysis. Trace assignment closed, no report. And what you also see is that between January 3rd, 2023, which is the date of that entry, and the date the Massachusetts State Police Lab apparently closed this case, and February 8th, which is the date that Mr. Lally stood here in court and made those representations that he was so desperately trying to expedite testing, there is not a single record of communication between Mr. Lally and the lab that's contained in that conversation log. That's not Mr. Lally's hands being tied by lab protocols and lab procedures. In fact, the assignment was closed because he failed to answer his emails. That is deception, Your Honor. So when the Commonwealth stands up and says that the defense can have access to the physical evidence in 30 or 60 days, that's not good enough. We need court intervention. We need this court to order the Commonwealth immediately provide us access to these critical items of evidence and set a date for compliance, because that's what the law requires. That brings me to the second category of evidence that we're missing. Your Honor, for quite some time, we've been asking for access to the Lexis infotainment system and the Lexis telematics system. As of this morning, our expert was able to get in touch with Trooper Garino, and they're currently working on coordinating a time
The thing that I like about this is that this testimony is clear, it's concise. She doesn't have any type of angst in her voice. She's just giving the facts. She doesn't sound like she's bitching. I love that this is getting on the record. Let's just say Karen Reed does get convicted of this, which I don't think that she will. This would be great in appeal. But she's direct, she's clear, she's concise. If you wanna compare this to Ann Taylor, she's smashing Ann Taylor right now. Just the way that she is direct, the way that she's getting this information out in clear and concise on the record. Super, super good. Great lawyer.
Time to hopefully analyze that evidence. I'm hopeful that the Commonwealth will be forthcoming and allow us to obtain our own analysis.
Not being accusative, just being direct. Great lawyer.
If there are any issues, we will plan to file a proposed protocol for the examination of that evidence with the court, but I'm hopeful it won't come to that. The third category of evidence is the handwritten notes of law enforcement. As this court is aware, it was filed with our papers. Law enforcement was ordered to preserve all handwritten notes taken in connection with this case. That was done in Stoughton District Court on February 2nd, 2022. And I know Your Honor sort of reaffirmed that order just in passing during one of the court appearances when we asked for her to renew it. We know law enforcement took copious notes in this case because most, if not all, of the reports were drafted weeks, even months after the actual interviews or investigation took place. We're asking for the court to immediately set a compliance date for production of those notes. If the Commonwealth has nothing to produce, then we also need confirmation of that because it's in violation of a court order. The fourth category are reports, handwritten notes, and mapping documenting the recovery of evidence from the Albert residence. This information should have been produced.
Mary, go back about 5 minutes. Go back about 5 minutes. You're going to want to listen. It's going to blow your mind. Go back about 5 minutes, Mary.
Over a year ago. If you were to review all of the police reports in this
I'm going to
case,
redo the poll right now.
as we've done, then you might mistakenly believe that there were only 2 searches of the lawn of 34 Fairview Road that resulted in the recovery of taillight pieces. Those searches were on January 29th at 5:45 p.m. by the CERT team, and there was a second search on February 3rd, 2022. But those reports are not complete because according to photographs of the evidence bags in this case, which we just received on July 25th, Trooper Proctor claims to have actually recovered taillight pieces over the course of 5 additional undocumented searches of the Albert residence throughout the month of February. The only reason we even know about these searches is because when Trooper Proctor logged these pieces into evidence, he had to write his name, the date, and the place those pieces of taillight were supposedly found, 34 Fairview. That's 5 undocumented searches, Your Honor. We don't have a police report for any of those. No notes, no reports, no photographs of where those taillight pieces were found in the yard. No memorialization of the individuals who called Trooper Proctor to the scene. That is not acceptable. If this information exists, we're entitled to it. We need a short compliance date for the production of these notes.
We're trying to make it grow. Thank you.
We can at least prevent further fabrication of evidence.
Thank you.
The 5th category of evidence, Your Honor, is the raw data associated with the CERT team search on January 29th at 5:45 p.m. We received a disc this morning from Mr. Lally. I obviously have not had a chance to review that yet, so I don't know what's actually contained on it. This has become somewhat of a pattern in this case. So I'm hopeful that everything's on there, but I'm not able to guarantee that for the court. He also indicated that there are additional materials that are forthcoming. Obviously, we haven't received those yet. I'm asking the court to set a compliance date to make sure that we actually get the information that we've requested.
Okay, thank you. Mr. Lally?
Your Honor, I'm not quite done.
Oh, you said there were 5.
I was going to have a conclusion if I may
Okay.
finish addressing the court. Thank
Sure.
you. Your Honor, we are entitled to this discovery and we need compliance deadlines. Ms. Reed has a constitutional right to a speedy trial and to prepare and present her defense. The law is clear that Ms. Reed was supposed to have access to all of the requested information in August of last year. Respectfully, Your Honor, we're asking you to please enforce these rules and get Ms. Reed the discovery that she's entitled to. Thank you.
Thank you. Come on.
Yeah, sure. Most of what I believe was just addressed was dealt with in the Commonwealth's response.
Sure, he's speaking in a microphone right in front of him, but if you can't hear him, can you go over to the podium, please?
That's fine. So, Your Honor, I believe most of this.
I'm going to address this really quick. Miss Krampus in 1999. Thank you for the support. I really do appreciate that. She says, thank you to LTL community and Brian for being a welcoming community, even for inquiring minds who question everything. Brian, love your coverage and all and all the old events as well. I remember crying during the Boston bombing stream. Yeah, that was really tough one. I mean, I'm from Massachusetts. I remember that day. It's really crazy. And unfortunately, YouTube doesn't like streams like that. YouTube doesn't like us to put out the truth and talk about it. You know, it was a horrible day here in the state of Massachusetts, and Boston had a lot of people scared. But they don't want us to talk about that. So they suppress the streams. They limit my ability to put them out, even though there's thousands and millions of documentaries all over YouTube about it. But thank you. You know, we're trying to grow this community. I don't get it. You know, I know I bitch a lot. I fight a lot. I scream at YouTube a lot. I want this channel to be great. I wanted to get it in front of 50,000, 100,000 eyes. I just don't get it. You know, maybe it's because I lean center right. Maybe I talk about free speech and I talk about Second Amendment rights. You know, hey, I'm a proud person. I stand up and I call bullshit out. You know, it seems to me that they love those conspiracy streams. They love the people that like to fight the system all the time. I am in no way fighting the system here. I'm just talking about if there's corruption and there's a cover up, then we need to expose that and get that out there and get Karen Reed, if she is innocent of this crime, get her, you know, off these charges and free for the rest of her life. But it's funny. I find the channels that fight the system, that say police are pigs and all this other stuff, you know, those are the channels that get pushed out in the algorithm. But when you support the police, you back the police, you know, say you care about your community, you care about the people that you talk about. You don't put false lies out there about victims. You don't put trash information out there for people to grab onto. You don't go on your stream and call women what's the word I'm looking for? Derogatory names. You don't tell them to get back in the kitchen. You know, for some reason, those are the channels that everybody likes to watch. And those are the channels that get pushed out in the algorithm. People that represent themselves as fake lawyers and call defendants their clients, you know, people that are not even from this country that shame our political system and our laws all the time. Those are the channels that get pushed. You know, it's unfortunate. It's really unfortunate. And I think that we have a very clean chat here. We have a great group of people that come into the lives every night and watch what we do. I will fight for my channel. I will speak up. I'm not going to be told how to run my channel. I'm getting sick of those emails too. You know, I get it. People are invested in this channel too. But you know what? At the end of the day, the bottom line is I have to do what's best for LTL and myself as a brand. Stop emailing me, telling me that my thumbnails are this and my content is that. That has nothing to do with you. If you don't like what I do, start your own channel. You don't have to watch LTL. You can go somewhere else. But I'm getting tired of that stuff too. It gets a little annoying after a while. This is my channel. This is my content. People come here for a specific reason to watch what we do here, and they want to be part of this community. I'm not going to change who I am, and I'm not going to change what I'm doing. And if I feel a certain way in a case, then I'm going to feel a certain way in a case, unless there's evidence in front of me that can convince me to go a different way. I'm sorry. And that's how I feel about this. I don't feel right now, as what I'm hearing and seeing, that Karen Reed did this. I'm sorry. I might lose some people on this. But unless you can tell me otherwise, and we're hearing it clearly today during this hearing, you know, unless you can tell me otherwise. But anyway, I'll keep moving on here.
I've addressed in the Commonwealth's response, and just to be clear, it's not an opposition to the defendant's motion. The Commonwealth is well aware of its discovery obligations under Rule.
I literally had someone today, and I'm sorry, I'm stopping this again. I literally had someone here today that was consistently in my chats like 3 months ago, haven't been around, and they email me and say, "Oh, sorry, I haven't been around. I caught some of your videos, and this is what I don't like about your channel, X, Y, and Z." And then at the end, it's like, "Oh, congratulations about the 10,000 subscribers." Like, who are you? Who are you? You know, who do you think you are? Oh, I'm going to continue to support you and push you because someday I want you, and I don't care. I hope they're watching. Someday I want you to do this full time. Well, yeah, I do want to do this full time, but you can't come in here and tell me what to do on my channel. Like, that's like, who are you? If you don't like what I'm doing, do it, make your own channel. And I think that's why maybe some people, I rub people the wrong way because I stand up for myself and I don't fold. You know, I'm not a person that's going to fold. I have a backbone in this. I might speak up a lot more than you know, your usual YouTubers. You know, yeah, I try to keep a clean image. I try to keep a honest, wholesome channel as well. But if someone's pissing me off, I'm going to stand up and say it. Listen, you know, like it's my way. I'm sorry. There might be things that I do here that you don't like. You can just hit the unsubscribe button. It's really easy. You don't have to come to the lives. But I'm getting tired of that. That's annoying. People like email, "Oh, you should do this, you should do that, you should do this." Like, listen, I round my content on what I choose to cover here, and I appreciate it. People send me stories. I appreciate it. That's very nice. I get those emails. "Hey, you should check this out. Maybe this lead. Hey, I just saw this dropped. Maybe you want to do something about it." I like that. But when you come in and you critique me in my email and you tell me, "Oh, you shouldn't do this and you shouldn't do that and you shouldn't do this," I'm not even going to listen to you. You know, just move on. Just move on at that point. All right, let's get back into this. Blah, blah, blah. My rant for tonight. Da, 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 da. Look at Turtle Boy smile.
14 does not oppose the defendant having access to these items. It's merely a
no, I don't even answer.
Timing.
I don't even
Now,
answer
as
them.
it pertains to the first enumerated item, and there's been various modifications of this. And what I would say is that the Commonwealth is very aware of its ongoing obligations under Rule 14A1A, under Rule 14A4, as it pertains to mandatory reciprocal discovery and exculpatory evidence, and has provided counsel for the defendant with we're close to 300 items of discovery at this point. So this is not a situation in which the Commonwealth is I would submit, withholding evidence or preventing the defendant from doing any, receiving any discovery. As soon as the Commonwealth receives it, it's provided to counsel. There was somewhat of an issue at some points over the history of this case where I had been providing discovery to Mr. Yannetti that apparently wasn't making its way to either Ms. Little or Mr. Jackson. My remedy for that has been to provide whatever I can, especially documentary evidence and attachments, email, so that it goes to all counsel. And
and by the way, thank you so much. You know, she's you know, this is a good person. This is a good person. Someone that's come on my chat, been very respectful, been here for a little while now. Gave her a shout out, had her on the panel, gave her a little exposure on her channel. You know what she does for me? Every time I drop a video, I go, I'm not down that much with Twitter and all that. She's always tweeting my stuff out. That's really nice. That's someone that's, you know, a supporter. And you know, when I have the time and I can go over and watch some of her videos or drop in the lives and say hi, I can do that. But someone, you know, that's here consistently supports the channel. That's very nice of her to do that. You know, that's very nice. That's what we should be doing. Don't email me and say, you shouldn't do this, you shouldn't do that, you shouldn't do this. And then at the end, you're going to go, but I still support you. You know, you can go blow it sideways. I don't want to hear that crap.
All counsel have access to it, which
I don't want to hear it.
caused some of the delay as far as the testing of the lab is concerned in the first place. The lab was prepared to conduct its initial DNA testing back in May, had to wait until July, and then There was a second subsequent exhaustive testing, which wasn't conducted until August 1st because of the timing in which we received the exhaustive authorization form from counsel. What I can say is Ms. Little and Mr. Jackson were very good as far as soon as they were made aware of the issue, they executed the forms. I received them, forwarded them to the lab the same day. But unfortunately, all of the DNA testing was not able to be completed on that July date because of how late we received that particular assignment. As far as the items that are contained at the lab, again, these are the lab's policies. They're not my policies. There's nothing as far as anything that the district attorney's office or myself has done, any suggestion that we're desperately withholding evidence from the defense as we're afraid of what it might show is just patently ridiculous. The items that are at the lab there's no objection to counsel swabbing anything from any of those samples, inspecting them, photographing them, doing whatever they would like with them. The issue is when the lab is done. And as I detailed in the motion, there was a recent trace assignment that was completed, not recent, but several months ago, actually. And
why does this guy always seem like he's backpedaling?
It had to do with item 3-1 and several other items pertaining to the tail light. And so 3-1 is the passenger side rear tail light of the defendant's SUV. Items 7-5, 6, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 19 were all pieces that were recovered from the area where Mr. O'Keefe's body was discovered in front of 34 Fairview Road. Now, each of those were subject to a comparison analysis in which they were essentially fitted back together with item 3-1, which was the actual unit from the defendant's SUV. That was believed to be done. So the lab at that point had made a forensic link and was believed to have been done with testing related to that. Subsequent to that, there was a subsequent discovery based on some additional testing in relation to item 7-18.18. And that essentially was microscopic pieces. And when I say microscopic, they measure approximately, probably less than 1/16 of an inch of clear and red plastic pieces that were recovered from the victim, Mr. O'Keefe's clothing, specifically his shirt. Based on that discovery or analysis, there was then a subsequent trace assignment that was created in relation to comparative testing for those microscopic pieces to item 3-1. Again, an item that the lab had theretofore thought that they were had completed with. There's also an ongoing trace assignment for comparative purposes to some glass that was recovered from the rear bumper of the defendant's vehicle, comparing it to pieces of what they describe in the lab notes as cocktail glass that's found on the ground near Mr. O'Keefe and near Mr. O'Keefe's shoe. Of note, what I would say is that Mr. O'Keefe is observed leaving the Waterfall Bar last time that he's on video, carrying a short cocktail glass in his right hand as he's leaving from that facility. So that trace assignment is open. The DNA results from the July testing has been completed and provided to counsel. The DNA testing results from the August 1st testing, my understanding, should be completed. And again, these are not promises that I make. These are estimations based on what the lab can tell me as far as their expectation of when items will be completed. But the DNA testing, I anticipate, should be completed on or around September 26th. Those two trace assignments should be completed sometime in the last week of October. And there is additional DNA testing that has just been scheduled to be undergone shortly. As far as whatever the court deems appropriate to impose, obviously the Commonwealth will comply with that. We'll make arrangements with the lab. They do not allow outside personnel into the lab, so it'll be a situation where obviously items that are currently undergoing testing are not going to be taken back from the lab, but if there are any items that have no forensic value left to the lab, once this sort of round of testing is completed, we will certainly pick those items up and make them available for counsel. But
Do you anticipate that this will be the last round of testing for DNA?
I anticipate it will, but at the same time, it depends on what the other testing shows. So it's typically what the lab is going to do is they're going to test until they get a forensic link, or they Either they do or they don't. But basically, so without knowing what the results of the testing that's just undergone and is just about to be undergone or is undergoing currently, I can't speak to as to what those results would be, and therefore I can't speak to whether or not there would be any need for additional testing.
Can't speak to anything, can you?
As it relates
It's
to
the prosecution.
the Lexus infotainment and telematics, I'm just a little confused because initially how it's phrased in the motion to compel is it's sort of incorporating all kinds of different materials. So it's talking about an ACM, EDR, LSS. Now the ACM is the airbag control module in the car. EDR is the event data recorder. LSS is the Lexus safety system that's specific to a Lexus. All of those items are in the vehicle. And I've endeavored to arrange, should council have an expert that wishes to view or download that material directly from the vehicle themselves, all of that material, including the raw data, has already been provided to council. Way back in May of 2022, Mr. Yannetti had retained a reconstruction expert who had actually gone to the vehicle and downloaded the ACM material. So I'm just, what I was told most recently is that they don't need to look at the car, or they don't want to meet with Trooper Paul from the CARS unit to do anything with the car. As far as it pertains to the Burla and the telematics, as I stated previously to Your Honor in court, the issue is, and just for the court's understanding, the Burla is, think of the Burla as a Celebrite for an infotainment system. So it's essentially the software that downloads it. The issue is that Burla, which is essentially really at least the only certified forensic tool that I'm aware of that pertains to those types of systems, they receive updates periodically from the manufacturer. I believe there's another one coming up in a month or so, but I have no information. We reached out to Burla numerous times, but I don't have any information as to whether or not this make and model of a Lexus is going to be part of that update that they provide. But up until we receive an update that can actually read and parse the data that's contained therein, it's an issue as far as, you know, there has been data that we've extracted and we provided to council, but it's essentially unreadable data at this point. I am aware that Trooper Guarino from our office spoke with council's expert yesterday, actually, in regard to seeing what can be done, what had been discussed, and what I had discussed and discussed in the Commonwealth's response is what's called a chip-off. Now, a chip-off is something that doesn't just pertain to the Burla or to the infotainment system. It also would apply to an event data recorder. It's the issue with the chip-off is that it can be and likely would be destructive. So essentially what it involves is sort of burning the chip off of the unit. And in that process, sort of inherently within that, can be destructive to whatever data or material is in there. And you don't know that until you've already completed the process and started to look at it. And that is the reason that the Commonwealth has not endeavored to do that at this point and has opted to wait and see sort of if we can get an update from Burla or from the manufacturer to Burla so that we can read and parse the data. If that is something that council is interested in doing, again, I've spoken to Ms. Little a little bit about this, that the Commonwealth certainly is not going to conduct any of that testing without them having an expert present to do any sort of chip-off or any kind of destructive testing whatsoever. But if that is something that council is interested in, I would encourage council to file a motion with the court, as would be done with any sort of destructive testing. And if that's something that the court orders us to do, obviously we will be present, and council will have an opportunity to be present with an expert as well. The third category, I believe Ms. Little was referring to notes of law enforcement. Absolutely no issue with that. It's been requested. I should have those in a short frame. If the court wants to order their production within, say, 2 weeks, that's absolutely fine. Reports, notes, and mapping from the CERT team. Again, these are items. What Ms. Little was referring to today is a GPX file that I just received yesterday from the CERT team, and that's why I'm providing it today. Obviously, sending it in the mail wouldn't do as good as handing it to Ms. Little today. But essentially, what I put on that disk is a GPX file, and it's a file that contains data that can only be opened in a mapping software. So in addition to the GPX file, I also put some mapping software onto the disk to make it readable. If council wishes to use a separate software application, obviously they're free to do so.
When do you expect to be able to do all that?
So that was provided today. The other part, as far as notes from the CERT team, there are no notes from the CERT team. I spoke to Lieutenant O'Hara from that unit. There are no notes. They have reports, they have diagrams, they have the mapping raw data. The only thing that I'm currently waiting on and should have in the next few days or so is in relation to, I don't even know if they asked for it, but it's something that I was looking for as far as dispatch logs and ALV data as far as when they were dispatched and when they arrived at 34 Fairview Road, all of which should be logged. Similar to items that's been previously provided in regard to the Norfolk County detective units. As it pertains to Trooper Proctor, 5 undocumented searches of the residence, I don't believe that those occurred. I will certainly look into that. And if there is any documentation related to those, whether they be notes, whether they be photographs, whether they be reports, again, the Commonwealth has no issue providing those in short order. That's something that I've heard of the first time today while I was sitting here in court. Now, I believe the 5th thing pertains to the raw data, which.
Yeah, I talked about that, lady. I talked about that. I said that the night that they were in the waterfall together, they were hugging and kissing when they left. There was no sign of any argument between them. Everybody in the bar was having a good time. So yeah, I talked about that. Absolutely. I just ordered a free Karen Reed t-shirt from Turtle Boy. If you're gonna go over there, I can drop for the ladies. Here's the link for the ladies if you want to order one from Turtle Boy Direct. I just ordered a men's. I'll be wearing mine soon.
Again, the Commonwealth provided this morning. So as it pertains to this or any discovery, there's been a number of other discovery items that Ms. Little and I have had conversations in regard to over the last several months, over the last however long it's been. But I would submit that when I'm asked of things, asked for discovery, formally, informally, whether by formal motion or not, the Commonwealth has no issue with continuing to abide by its duties and obligations under Rule 14. Whatever discovery I have or whatever discovery that I can provide, I'm happy to do so. That is.
Okay, Ms. Little, any follow-up with that?
Mr. Lally just listed a lot of lab work that has been done in terms of DNA testing. I just want to clarify for the court. I did review his opposition. There are only 2 items that are still subject to comparative testing. So we're asking that the rest of the items of evidence be made available to us immediately. There's no reason to continue to withhold those from the defense. As to the Lexus infotainment system and the telematics system and the EDR, as Your Honor can imagine, it's quite expensive to fly an expert from out of state to go look and interpret this data. We're trying to avoid having to do multiple trips of that. So while I understand the airbag control module and the EDR, which we already do have the data from them, are generally available, we're not going to have our expert fly out to do that until she can actually look at the stuff that's of substance, which is the infotainment and telematics system. As far as that's concerned, I know Mr. Lally has made representations to this court that the infotainment and telematics system have no recoverable data and have been hooked up to Burla. But Burla is just that. It's like Celebrate. There are hundreds of other softwares out there that are able to read and parse this data. Our expert is aware of what those programs are. She would like to be able to analyze the data. She believes that there's likely ways to do it that are non-destructive. She has reached out to Trooper Garino to inform him of this. He seems to be receptive to doing that.
Okay.
She won't know until she actually looks at it what particular softwares will be appropriate. We haven't been able to get that information from the Commonwealth because the actual photographs and things she needs to look at to see how to analyze the data, we still have not received from the Commonwealth.
So you say that your expert is talking to the Commonwealth's expert today or yesterday?
Yes, I believe actually this morning is when I received
so
the email.
after they talk, if you put in writing to me a protocol that you say your expert says there's hundreds of other methods of being able to read this data. Put something in writing. It sounds like the two experts should be able to work it out, but if not, we'll deal with that. But I do want to know about that.
That's my hope. Thank you, Your Honor. With regard to the 5 undocumented searches, we don't have reports on those. Like I said, we have photographs of the evidence bag that shows that taillight pieces were not put into evidence until late February. There were 5 undocumented searches. They came from somewhere. So we need reports on those. And with that, I will submit, Your Honor.
Mr. Lally, earlier when you talked about the DNA, you said that on 9/26, one item, the testing should be complete, the other, the last week in October, and then you said the third, you were looking for a date, but I think you said soon. Do you know when whatever the third part is that you were talking about?
So to be clear, the 9/26 date was in reference to the DNA work that was completed on August 1st.
Yes.
That was a second round of exhaustive testing in which their expert, Mr. Lakin, was present. That we had to delay because of his, first, his availability, and second, not having the exhaustive testing form completed. The second that I was referring to in late October is in regard to 2 separate trace comparison analysis. That's sort of the estimated time of those reports completion. And then there is a subsequent 8 items that have been selected by the lab. And just to be clear, these are items that are selected by the lab, not by our office. For DNA testing that has just, they don't require exhaustive testing. So that has just begun to be, I think it's scheduled within the next week or two to undergo that testing. And then just my own sort of estimate as far as typical turnaround time for DNA, in which, it has been communicated to the lab on numerous occasions, every single bit of testing that's been done. As per the court's suggestion and direction, I've requested expedited analysis with regard to each of those. So that I would expect probably around the same time frame, late October, early November, as the trace comparison.
All right. So what I'm going to do is I'm going to order expedited testing on those 8 items that have not yet been tested. And I want the Commonwealth to be able to report back in the beginning of November the results of all of the testing that's been completed. And if it's not completed, why, and when you expect it to be completed. Why don't we have all of that by November 3rd? For B, the defendant's request number 4, for the infotainment, I do want the 2 experts to talk. I need more information on this. If it's something that there is other software that can read this, then we can move quickly with it. So I need to get that from you, Ms. Little. You need to talk to the Commonwealth. Your experts need to talk, and you need to put something in writing for me on that. Stand up at the microphone so I can hear you.
Can we have a compliance date for discovery from the Commonwealth so we can get the reports and the photographs we've been asking for so that our expert can make that analysis? She needs to know exactly what's in the car and have pictures of the circuitry.
Your Honor, if I could just speak to that. So the photos are on a disc and in the papers that I handed to Ms. Little this morning. Also, when I spoke to Trooper Garino, he indicated that following his conversation with Ms. Gaffney, who was the defendant's expert, yesterday afternoon, that he had forwarded an email with each of those photographs to Ms. Gaffney directly.
Okay. So if you talk to her today, if she still needs them, put them in writing and we'll order them to be produced. All right, so the request D, is the Office of the Medical Examiner, is that all taken care of? The original death certificate? You didn't raise that this morning, Ms. Little?
Yes,
So,
Your Honor.
okay, so request number 5 is all set?
Yes, Your Honor.
Okay, so regarding the request for all of those notes, a 2-week date. So let's get that by the 29th of September. I'll give you the same time frame to see about whether there are any photographs, handwritten notes, mapping, documenting the recovery, the 5 undocumented searches that are outlined in E of the defendant's response, reply to the Commonwealth's response.
I think that I just have a feeling that if Karen runs out of money for her defense, I truly believe that these lawyers would just stay on. I truly believe it. I think they are fully vested. I think they 100% believe that Karen did not do this. I really, truly believe in my heart that they would just stay with this case.
So 2-week date for that, 2 Commonwealth 929. The Commonwealth says that there is no raw data with the CERT team or no notes. Why don't you just tie up all loose ends and put that in writing, Mr. Lally, by 929?
Yes, Your Honor.
Okay.
Thank you, Your Honor.
Okay. That was the whole purpose of today's hearing, was to be able to do that. So at least we've got that done. Now we move on to the Commonwealth's motion for an order regarding expedited testing. And the Commonwealth has asked me, I believe, to impound the results here, Mr. Lally?
As far as the attachments to the motion, yes.
Yes, okay. Is there any objection to that from the defense?
Let me have just a moment, Your Honor.
Your Honor, I'm sorry. Did you say expedited testing or were you referring to exhaustive testing? Is that what you're asking?
Exhaustive testing, the Commonwealth's
Okay.
motion.
I'll let you address that.
So, okay.
Your Honor, there is an objection.
Okay, so let me hear the Commonwealth then on the
Fine.
motion, then I'll hear your
That's fine.
objections. My question was simply on the impounding of the attachments. There's an objection to the impounding of the attachments?
No.
Okay, that was that question. I'll let you be heard on the motion, Mr. Jackson, but I'll hear from the Commonwealth first. And Mr. Clerk, the results that are attached here, Commonwealth satisfied me that they qualify for impoundment, and I will impound them. Yes, I'll put that in here. All right. Mr. Lally, I'll hear you on the exhaustive testing motion.
Yes, Your Honor. So very simply put, there is 2 items that, as I just referenced earlier, had been subject to DNA testing in July of this year. Among those items was the root end of a hair, item 3-6.1, from item 3-6, which was a hair that was recovered from the rear bumper of the defendant's vehicle. The testing that the Commonwealth is requesting would surely be exhaustive based on the size of the sample. The MSPCL, the State Police Lab, does not have the ability to conduct mitochondrial DNA testing or the testing that the Commonwealth is requesting be done in this case. We've identified an external vendor. This item was initially marked by the State Police Lab for an external vendor because of that reason, because of the size of essentially what is the shaft ends of the hair. And for those reasons, the Commonwealth is requesting that it be permitted to send it to Bodie Technologies in Lorton, Virginia, which is a lab that the Commonwealth and Defense routinely use. I don't think there's any question as to the ability of the lab to do said testing. I've also attached as Exhibit C, reached out to Bodie just because obviously, whereas it would be exhaustive testing, we were curious, or I was curious as to whatever their policy was regarding observation of testing procedures. They do somewhat allow for it, but it's more sort of behind glass. And
It was helpful to me to be able to read it.
So for those reasons, whatever, I mean, that is something I think that is up to the defendant through her counsel as far as how she wishes to exercise that. And I'm sure whatever their choice is can be arranged with the lab. But whereas the testing is exhaustive and it be sent to an external vendor, I felt that a court order was appropriate in order to, prior to sending that sample off and conducting that testing.
So you are not asking that I impound Exhibit C?
It certainly doesn't have to be. I just did it as A, B, and
No,
C.
the only thing that requires is A and B. So I'm only impounding A and B.
That's fine.
All right. All right. Now I'll hear you, Mr. Jackson, on your opposition.
Your Honor. As it pertains to the hair, the history of that hair is somewhat tortured. The Commonwealth has been trading on the argument in front of this court and in arguments, both oral arguments and motions that they've propounded or filed, that this item that was found on the back bumper on 3-6, which is 3-6.1, is in fact a human hair. They've gone so far as to suggest the relevance of that item is it's not just a human hair, it's John O'Keefe's hair, which would establish some sort of physical evidence that my client is, it inculpates my client. Except when we demanded that the hair be tested under the watchful eye of one of our own experts, which we had not had the advantage of doing at any time prior, it turns out that it wasn't a human hair. On August 25th, 2023, there was DNA testing done on 3-6.1, and the analysis resulted in, quote, no human DNA detected. STR analysis not performed. I'm holding the DNA results. So after a year and a half, so 19 months or so of saying this was a human hair on the back of that bumper, turns out it's not a hair. And DNA testing indicated it was not a hair. And now the Commonwealth seems to be in some sort of triage mode to try to figure out how they made a mistake. And the mistake is, actually, I question whether or not it was a mistake, because you can make a mistake once. I don't know that you can do it 4 separate times. In 4 different filings before this court, 4 separate times after August 25th, after they had this document in their hand, because the highlighted portion says, no human DNA detected, they filed motions with the following phraseology. Quote, the hair has been forensically confirmed to be a human hair, end quote. Not once, not twice, 4 separate times. And the last time was just this past week when they filed something in front of the Court of Appeal with that exact same phrase. The hair has been forensically confirmed to be a human hair. Your Honor, at some point, that's not a mistake. That's a deception. That's a knowing fabrication. That's a lie. And I don't use that word lightly. I'd love to consider this conduct feckless and irresponsible, but it's not. To do this 4 times, this is pernicious and it's intentional. So when the Commonwealth comes to us at the 11th hour and says, oh my goodness, hang on a second, let's all take a time out. We want to destroy the very item that we've been trading on falsely for 18 months to do mitochondrial DNA testing, which, as Mr. Lally indicates, he's smart enough to know, the lab is smart enough to know that's completely destructive testing. That will be exhausted, it's gone after the mitochondrial DNA is done. I expect that Mr. Lally will say something along the lines of, well, we were just trading on the idea that Maureen Hartnett at our crime lab microscopically confirmed that it was a human hair. And she did. What's the problem with that? She failed her proficiency exam the month before she did the examination on the exact same issue, and it's not like a generalized proficiency exam. It's a proficiency exam dedicated or focused on whether or not she can microscopically determine a human hair. And she failed that.
I mean, you know, it's bad when you have the court laughing. Like everybody in the court just laughed there. I'm telling you, this is what I mean. Like everybody needs to get their eyes on this case. This case is so important. And I'm going to keep screaming this until I have 200, 300, 400 people in these lives. You are missing out on this case. If you are looking for, and I hate to say this, absolute drama that everybody looked for in the Idaho 4 case. Everybody looked for that. They were gripping their fucking nails on edge, biting their nails down to their nail bed because they wanted the next piece of evidence or non-evidence or cover up or whatever. You need to get your eyes on this case. If you like that stomach feeling like when you're riding a roller coaster, I get that when I discover things in a case, or I come across something and go, oh my God, I get that feeling. I know what it is. And I know you all get it because we get invested in this. This will give you those feelings every day you listen to something or read about something in this case. Get your eyes on this case. It's very, very important.
So they have Maureen Hartnett saying it's a human hair. She's not even qualified to say it. Then they go back and DNA test it. It comes back not to be a human hair. Then they say we want to destroy it. My position is,
I mean, if you were waiting for the hearings of all hearings, this is the hearing that you needed to hear today. I urge everybody to go back and watch this on replay. It's a very important hearing.
it should not be destructively tested, certainly not by the Commonwealth. I understand, I know the Bodie outfit in Virginia, the third-party outfit. They've got a good reputation. However, before anybody gets their hands on that hair, I don't even know if it is a hair, quite frankly. Before they get their hands on that item and destroy it, I would ask that that item be made available to us. This protocol is undertaken all the time throughout the country. Have it sent to an expert of our choosing, and we have one in mind out of Chicago, probably the most well-reputed microscopic analysis shop in the entire country. We'll have them employed to look at it microscopically, make their own determinations. At that point, Mr. Lally, myself, we can agree if, in fact, the results are satisfactory to have it exhaustively tested, but certainly not now, not after this, as I said, tortured history of this item.
Okay. So am I going to hear from Mr. Lally or Ms. McLaughlin, who wrote Mr. Lally, I'll hear from you.
Mr. Lally, I'm here for you.
Your Honor, as it pertains to the hair, so the analyst responds to the garage of the Canton Police Department, labels it as an apparent human hair based on the characteristics that she observes when she removes the item. The item is then taken back to the lab and microscopically analyzed. There are photographs that counsel has from the lab packet that's already been provided. I would submitting any of those photographs to whatever expert they want. I would imagine would concur with Ms. Hartnett's analysis based on those characteristics that it is a human hair. I believe what has just been stated is a complete misrepresentation of what that DNA testing report says. So what the DNA testing report says is that there was no human DNA detected. As the court is well aware, there are essentially 4 steps that are done in a short tandem repeat DNA analysis. The second step being quantitation. So when there is an insufficient amount of a sample, and that's why the root end of a hair is the one that's initially tested for DNA, because you're not getting DNA typically in typical DNA testing from the actual strand of hair, which you're using the root end in the hope that there are some residual skin cells that are left from that root end in order to conduct the testing. So when they get to the second step in this particular analysis, the quantitation, there is an insufficient amount of any DNA to be able to generate a sample or a DNA profile from. That's what no human DNA detected means, which I'm sure counsel is well aware of in its representations to the court to the contrary. So the STR analysis is not done on the root end of the hair because there is an insufficient sample for them to even replicate in that quantitative second step. So the findings from the criminologist or the criminalistics expert as a microscopic evaluation of that particular item and identifying it as a human hair is not incongruous with the finding from the DNA that there was no human DNA detected on that particular item. So as far as this particular item being sent, we're not looking to destroy the item. It's based on the item's size that any further DNA testing is going to exhaust the sample. We're sending it to an outside lab, to an external vendor, and that external vendor does provide for some opportunity for the defendant to send an expert to observe said testing. So there's nothing that's being hidden here or kept from the defendant. All items as far as that microscopic analysis are concerned, lab notes, photographs, everything pertaining to that has already been provided to counsel. All of the testing results have been provided to counsel, and we're asking for it to be, for the court to order or allow or permit it to be sent to this external vendor to conduct this testing and bring in the order before the court because of their observation policy and because the likelihood of the exhaustive nature of the testing.
If the testing is to occur, did they give you a timeline as to, I'm going to hear from you in a minute, Mr. Jackson. I just want to know the answer to this question. Did they give you a timeline as to how quickly that could occur?
I believe 2 months or so is the estimate that I got.
All right. I'll hear you now, Mr. Jackson.
At the end of the day, all we're asking for is to have the item reviewed microscopically that has nothing to do with any destructive testing whatsoever. It's going to be reviewed microscopically by somebody who actually knows what they're doing. And my problem with Mr. Lowley's response, and I understand why he's responding this way. Well, there's no deception here. We weren't pulling the wool over the court's eyes or counsel's eyes or anybody else's eyes. It looked like a hair. Why didn't they say that? Why didn't they say it looks like a hair as established by our expert who failed her proficiency examination? That would have been a truthful statement. But the statement that they've repeated over and over and over to this court in papers and in affidavits under oath, under penalty of perjury, is the hair has been forensically confirmed. There is no, you can't word salad your way out of that.
No,
Forensically confirmed means it's been DNA tested to confirm forensically and scientifically that it is a hair. Then they turn around and try to confirm it forensically. And there is no human DNA detected. I understand that the short tandem repeat testing, the mitochondrial testing, has not been done yet. That's their 11th hour sort of Hail Mary to try to cover themselves for what they've already done, which is to basically defraud the court in not one, but two, but three, but four different filings. 3 in front of this court, 1 in front of the Court of Appeal. It just doesn't pass the smell test. What we're asking for is very simple. We can address the mitochondrial destructive and exhaustive DNA testing at some point down the road. We want access to that item so that we can confirm whether or not it's even microscopically been properly analyzed. That's all we're asking. And I'll submit.
Can you get me an affidavit from your expert as to why photographs are not sufficient?
I can, and I can, as an officer of the court, I can certainly indicate to the court that this has been done enough. I'm experienced enough to know that they can't do it vis-a-vis even a micro photograph. They have to see the item in person, but I can get a declaration to that effect.
And how the procedure would be conducted and how long it might take. Put all of that in writing for me, and I'll consider it when I consider this motion.
Thank you, Your Honor.
All right. So we'll move on to Mr. Yannetti's motion as to why I should change the conditions of release.
Thank you, Your Honor. May it please the court, I appreciate the opportunity to be heard. Your Honor, I stand before you because it is in the interest of justice for this court to lower my client's bail to personal recognizance in exchange for Ms. Reed turning in her passport and signing a waiver of rendition. We make this request because there are numerous important changed circumstances that have come to light since bail was last considered and modified. We also make this request because my client's finances continue to be drained and depleted as she struggles to pay the multiple experts she needs to properly defend herself in this case.
So before we go any further, I saved this motion to the end because you indicated that I would have an affidavit from your client as to her finances. I do not have that.
Yes, I did not file that electronically. I had told your clerk.
But I still don't have it now.
I have it in my hand, Your Honor.
So that doesn't help, does it, Mr. Yannetti? I need to read it.
No, I'm happy to pass it up.
So just give it to me and let me read it.
I just need to clarify. These are expenses since the last bail hearing.
All right, so give me a minute before I hear you on
Yes.
this. Has the Commonwealth seen this?
I'm filing it ex parte.
So no, I have not.
Oh, excuse me.
All right, so Mr. Yannetti, you've seen, I imagine, in your time as a prosecutor too, you've seen affidavits of indigency.
Yes.
But this doesn't give me enough information.
Well,
Doesn't give me enough information under Brangan, doesn't give me enough information at all.
My client has expended multiple, fees to not only experts, but also to lawyers prior to the last date as well, Your Honor. In terms of qualifying as indigent, I would argue that we have a little bit of a different situation here. Generally speaking, somebody qualifies as indigent because they can't afford an attorney, they can't afford any experts at all. That's not what we're saying. What we're saying is there's an overwhelming financial crush with regard to this particular case. And there are also, I should say, many more expenses to come, many of which have been already discussed by this court with regard to the multiple experts.
Do you want the opportunity to file a proper affidavit under Brangan? This doesn't give me the information that you know that.
We're happy to do that, Your Honor. I would still like to make my argument today.
Okay, you can make your, I can't make the findings under Brangan,
Right,
Mr.
well,
Yannetti.
but at the end of the day, Your Honor, if it's supplemented by an affidavit, then the court can make a finding at that point.
Okay, I'll hear you since you're here and you're ready, and we're doing a great job with timing. I appreciate counsel all being succinct today.
I appreciate that, Your Honor. As just continuing with my train of thought, the $80,000, our argument is, it's sitting in the Norfolk Superior Court Clerk's office now, serving no purpose other than to prohibit my client from using that money to properly defend herself. Your Honor, every time this bail has been discussed regarding this matter, both in Stoughton District Court and in this court, the Commonwealth has consistently maintained that their only justifications for requesting bail are, number one, the potential penalty my client faces, and number two, the nature and circumstances of the case. With regard to with regard to both, I'm concentrating my argument on changed circumstances. With regard to the potential penalty, in light of the changed circumstances that have and will be discussed during this argument, in light of what we've learned since the last time bail was modified, we believe, and my client well knows, the potential penalty she faces is nothing. There will be no penalty here because there will be no conviction. There will be no conviction because the evidence establishes her innocence. There is no jury anywhere who will ever vote to convict her for a crime she did not commit. And that leaves us, Your Honor, with a bail argument that relies really exclusively on the nature and circumstances of the case. And the nature and circumstances of the case, as represented by the Commonwealth during its numerous bail arguments regarding this matter, have been shown to be false. It is a fact that the nature and circumstances of this case have completely changed, even since the last time this court modified her bail. The nature and circumstances of this case, in fact, are night and day from what was presented to Judge O'Malley in Stoughton District Court at my client's arraignment there over 19 months ago. At that arraignment, Your Honor, having read only the scant information that the Commonwealth made available to me, it was still immediately clear to me that this case was a tragedy but not a crime. From the very start, with most of the evidence hidden from the defense, the Commonwealth's case against Karen Reed was extremely thin. And from the start, she had no reason to flee, because even without the results of our investigation, her defense was strong. And it was strong because it was based on innocence. By the time I got back to my office that afternoon, I had already begun to learn that this wasn't just a tragedy, and it wasn't just that my client had committed no crime. But shockingly at the time, I learned that somebody else did, in fact, commit a very heinous crime. A friend and colleague of Brian Albert's called me on February 2nd, 2022, only hours after my client was arraigned, and named Brian Albert and his nephew Colin Albert as potential suspects. That tip on day one of this case led us to do the investigation the Commonwealth did not do, the investigation they refused to do. And as my co-counsel has argued today, that investigation revealed that the Commonwealth's investigation was based on one lie after another. And the exposure of those lies is a major change circumstance which justifies lowering my client's bail to personal recognizance. I'd like the court to consider that at the outset of this case, State Trooper Michael Proctor submitted a report stating that Fairview Road in Canton had not been plowed during the early morning hours of January 29th, 2022. He claimed in that report that Michael Trotta at the DPW had told him during a phone call that he had with him after John O'Keefe was killed. We did not take Michael Proctor's word for that, and thank God we didn't, because we learned that was a lie. Rather than take Michael Proctor's word, we instead sent our investigator to speak to Mr. Trotta in February of 2022. He directed us to another man who led us to the plow driver who did plow the street. Our investigator interviewed plow driver Brian Laughlin within a couple of weeks of John O'Keefe's death. Mr. Laughlin told us what he has now told Michael Proctor, now that Proctor finally got around to speaking to him a year and a half after the fact. Shortly after John O'Keefe died, Brian Laughlin told us that he did plow the street in front of 34 Fairview, made a pass by there at 2:30 in the morning on January 29th. And when he passed that house, there was not a lot of snow that had fallen. Visibility was good. The lights were working on his plow. He passed right by the area where John O'Keefe's body would have been if Karen Reed had actually struck him with her vehicle. And he confirmed that at 2:30 a.m., plowing that area, there was no body there. And Mr. Laughlin was firm with Trooper Proctor. There was no body. And he told him not only was there no body, but if there had been a body there, he would have seen it. He left Michael Proctor in the Commonwealth no wiggle room. The plow driver's testimony should end this case. To put it simply, no body at 2:30 a.m. means Karen Reed is innocent. Forget about all the other evidence that points to her innocence, but this one fact alone prevents the Commonwealth from ever convicting her. No body at 2:30 a.m., she is innocent. But Your Honor, it's not just that he saw no body at 2:30 a.m. After that, he saw a Ford Edge parked right in the area where John O'Keefe's body was later found. Whoever moved that Ford Edge to that location in the early morning hours of January 29th, hours after Karen Reed left Fairview to go home, that person or persons knows exactly what happened to John O'Keefe.
I mean, there's a shit ton of reasonable doubt in this case. There's a shit ton of reasonable doubt in this case. I mean, just hearing this today, you know, read the PCA and then hear the defense. I mean, if I was on this jury, I could not convict her. I would say innocent. I'm sorry.
That mysterious driver and his or her accomplices likely know who beat up and killed John O'Keefe, and that person knows how John O'Keefe received all of the scratch marks and bite marks to his arm. This is all brand new information to you, Your Honor, as you did not have the benefit of any of this exculpatory evidence when you were deciding on an appropriate amount of bail. Frankly, when the Commonwealth relies on the nature and circumstances of the case in order to justify bail being set, those nature and circumstances have changed in such a fundamental and drastic way that I'm surprised the Commonwealth is opposing this motion. When you set bail, you did so in part on a representation by Mr. Lally at my client's arraignment that there was that apparent hair on the rear passenger side quarter panel of my client's Lexus. We now know that Mr. Lally relied on the gross examination performed by a criminalist who failed her proficiency exam in performing gross examinations of evidence. We now know from the Commonwealth's own testing that not only did the hair not belong to John O'Keefe, it turns out it wasn't even a human hair. That is a significant change circumstance from what was represented to you by the Commonwealth, and that would justify lowering her bail. When you last set bail, Your Honor, you had no idea that one of the Commonwealth's main witnesses, Jennifer McCabe, who had been at Brian Albert's house on the night in question and would have had to walk by John O'Keefe's body in the yard if it actually was there at that time, went home and at 2:27 a.m. Googled, "How long to die in cold?"
How long to die in
You
cold?
did not know when you set bail that Jennifer McCabe deleted that Google search. We have stressed to you ever since that our expert not only found that search, but we stand ready to prove beyond a doubt that Jennifer McCabe did it at 2:27 a.m. Our expert is certain. And importantly, the Commonwealth's handpicked expert, Ms. Hyde, confirms that the timestamp was 2:27 a.m., but says that the reason is unknown. This is all new information that you did not have when you have set bail in this case. And it goes without saying, Your Honor, that Jennifer McCabe's Google search, trying to determine just how much time had to pass before John O'Keefe would die in the cold, is completely consistent with her guilt or complicity in this crime and completely consistent with my client's innocence. You did not know this, Your Honor, at any time that you set bail, and this is a changed circumstance justifying a reduction. This is on top of the lies that have been uncovered. Not only did Proctor lie about the plowing of the street, not only did Mr. Lally represent that a human hair was found on my client's car when it wasn't, but importantly, Your Honor, you have been lied to by Brian Albert. In opposing our motion to get the animal control records, Mr. Albert's attorney told you that Mr. Albert's dog, Chloe, had no history of attacking human beings. Thank goodness you ordered the records, Your Honor, because we learned that was a lie. And to be clear, I do not believe for a second that Brian Albert's attorney, Greg Henning, would lie to this court. That leaves only one possibility. Brian Albert lied to him. Brian Albert told him that Chloe had never attacked a person. Brian Albert was desperate to keep these records secret from the defense and was willing to lie to keep them secret. The fact that those records have now been brought to court and reveal that Chloe attacked not just one, but two people in the past, sending them both to the hospital, is a major change circumstance. Brian Albert lied, which is powerful evidence of his consciousness of guilt. You should have been able to consider that before you set bail in this case, but that information was kept from you. It is now yet another change circumstance that justifies the lowering of Ms. Reed's bail. Now, I expect that the Commonwealth will argue 2 points in opposing this motion, both from lab reports. One, that John O'Keefe's DNA was found on my client's Lexus, and two, that there were microscopic pieces of taillights supposedly found on his clothing. Both of these arguments are red herrings. Regarding his DNA being found on the vehicle, our response is, of course it was found on the vehicle. It would have been shocking if John O'Keefe's DNA were not all over that vehicle, on every part of both the outside and the inside of the vehicle. He was in the vehicle that night, shortly before he was killed. He was around the outside of the vehicle several times that day and night. That vehicle was parked at his house for months. He lived with the owner of that vehicle. It's completely unsurprising that his DNA is on it. That finding does not undercut the new and powerful exculpatory evidence of no body being found in the yard at 2:30 a.m.
Gee, that's kind of funny. And I'm going to relay this to Idaho. He was just talking about the SUV having, well, of course there would be John O'Keefe's DNA on that. He was in and around her SUV. He was, driving that truck, using that truck. He dated Karen. And what DNA are we always talking about in the Idaho case? The knife sheath DNA. So if someone owned that item and they were around that item a lot and they touched that item, their DNA would be on it. And whose DNA was found on that knife sheath in the Idaho 4 case? Brian Koberger.
A Ford Edge being near the yard where the body was later found after 2:30 a.m. Give Jennifer McCabe Googling how long to die in cold at 2:27 a.m. And then 3 minutes later, Brian Lawfern driving by 34 Fairview and confirming no body there. Regarding the tiny pieces of taillight, for those to have any evidentiary value, you have to trust the person who had custody of John O'Keefe's clothing before it was.
So that would mean if Brian Koberger's DNA is found on that knife sheath, wouldn't that mean that it's his?
Sent to the lab.
So, Ms. Little, I'm not looking at any, if you show them to the audience before you show them to me, I'm not going to look at them. Okay, please put that down. Mr. Yannetti, do you have chalks for your bail? Please put that down. Do you have chalks for your bail argument?
I have one chalk that I was intending to show the court at the
So
appropriate time.
I don't need to see a chalk, Mr. Yannetti. You didn't give me sufficient evidence under Commonwealth versus Brangan.
Well,
So I will hear you because you want to make this statement. So go ahead, but no chalks.
You're right. Just so we're clear, it's not just her financial status that justifies reducing the bail. The thrust of my argument.
That's exactly what I was
all with
talking about,
regard to
Mary.
changed circumstances.
I understand that, so I'm going to let you continue. But a very important piece of this is missing. So go ahead with your argument. No chalks, please.
Yeah. And obviously my argument is, leaving the financial issues aside, the bail should be lowered based on my argument here today that I'm making to this court. I had just stated, Your Honor, that in order for the microscopic supposed pieces of taillight to have any evidentiary value, you have to trust who had custody of them, which means that you have to trust Michael Proctor. And I question, how on earth can anyone trust Michael Proctor? I've previously referred to him as being conflicted, which is certainly true, but it actually does not go far enough to describe what he has done in this case just by taking the case. The more appropriate word to describe him is corrupt. Only a corrupt state trooper would agree to investigate a murder case in which a body was found in the yard of a family friend. Only a corrupt state trooper would keep his ties to that family friend hidden. Only a corrupt state trooper would refuse to go inside the home, which featured the body of a dead police officer on its lawn. Only a corrupt state trooper would write in his report that a street had not been plowed when it had. It was the corrupt Michael Proctor who took custody of John O'Keefe's clothing, and that clothing was not submitted to the lab until several weeks after Michael Proctor seized it. You, I believe, have seen the chalk, Your Honor. That chalk shows that Michael Proctor is at the hospital. John O'Keefe's body is on a hospital bed. You see Michael Proctor's feet, and at the bottom of his feet, you see a pile of John O'Keefe's clothing, unattended, sloppily thrown on the floor. That's the care with which Michael Proctor treated what they now claim is important evidence. And that clothing was not submitted to the lab, Your Honor, until after Michael Proctor had seized my client's Lexus, and therefore seized pieces of the taillight. And you should consider how he treated the evidence afterward as well, in terms of not sending it to the lab until March of 2022. He had it for weeks. Michael Proctor's mother has described the Albert family as the Proctor's second family. Michael Proctor told witnesses who showed up to testify before the grand jury that Brian Albert is the salt of the earth. Michael Proctor's wife has posted about how much they love Colin Albert. The Proctors have constantly been photographed with the Alberts going back over a decade. We've shown that Michael Proctor's in a wedding party with Colin Albert. Colin Albert was the ring bearer at Michael Proctor's sister's wedding. It's so clear that Michael Proctor was both conflicted and corrupt. He had every reason to sprinkle tiny pieces of taillight that he had seized into the clothing that he alone took, so that the lab would later find it weeks later, and sure enough, they did. And this supposed discovery does not undercut the fact that Jennifer McCabe Googled how long to die in the cold at 2:27 a.m. and Brian Loughran went by and saw no body outside that house 3 minutes later. So legally, you have all the support you need to release my client on personal recognizance. There's also a practical side to this, which gets into the financial issues, Your Honor, and I'm almost concluding my argument here. You've seen my client's medical expenses in the past. You've been aware of her loss of income. You've also been aware of the numerous experts, witnesses, investigators we've had to retain to do the job that the Commonwealth either failed or refused to do. Those expenses continue to mount. She has not asked this court for a dime to pay for any of those expenses. We're now approaching a trial date, which we will request today. Those expenses continue to mount and indeed will skyrocket. She cannot afford to skimp on these experts. The stakes are too high. She needs every dollar she can to keep going, and $80,000 is a lot of money that would go a long way toward supporting her defense. To make it clear, Your Honor, we are not making this request without offering something in return. I would submit there's nobody in this courtroom who believes my client is a flight risk. Given the national publicity that this case has generated, which I submit will only intensify as we approach a trial date, my client is one of the most recognizable criminal defendants in America. Where on earth would she go, even if she wanted to go somewhere? But she's not going anywhere. Her family's here, her doctors are here, and given the strength of her defense, as illustrated by the changed circumstances we've discussed, she has every incentive to fight this case and no incentive to flee. She's made every court appearance and has invested herself 100% into this case, financially, emotionally, and intellectually. But if there's any concern at all, Your Honor, my client will dispel those concerns by turning in her passport. I have it. She's ready to give this to the probation department. She's ready to sign a waiver of rendition, any waiver of rendition the court would desire. So on this issue, she's really figuratively putting her money where her mouth is. Giving her passport and a waiver of rendition is far more valuable to this court in terms of assuring her appearance in court than $80,000 is. But that $80,000 is more valuable to her because she desperately needs it to defend herself. So for these reasons, Your Honor, I ask that you help us to level the playing field here. The Commonwealth has unlimited resources. My client does not. I ask that you release her on recognizance and give her the tools she needs to fight this case.
All right, thank you. To you.
Olivia, you need to reach out to me. We need to have a conversation. Reach out me via Twitter. Message me. We need to have a conversation. You know a lot about this case. I want to pick your brain and possibly, if you want to come on the show to talk about it. And if you have any connection to Turtle Boy and you can kind of wake him up a little bit and get him over here, I really would appreciate it. I mean, we literally worked out all the details and I asked him for a date and a time and he kind of just dropped off. So, I offer to pay him. I'm going to pay him to come on. I don't mind doing that. I understand podcasting, you have to do that. I worked out the deal with him. But I want to get him over here. And I've been emailing him. I don't want to bug him, but I've been emailing him and nothing. So I know he's busy, but I definitely want to get him over here. We need to have him on this channel. I mean, he's the front line in this case. All right, I got about another 15 minutes, and I do have to jet because I have another stream that I'm going to do at 9:30.
Want time to provide that affidavit to me?
I
quickly
want a
can you
good
do it?
quality hour out of him.
1 week?
We agreed to an hour.
Yes. Mr. Lally?
Just very briefly, Your Honor.
Yeah, no problem, Olivia. Tell him. We literally worked out all the details. I just got
Commonwealth just requested the bail remain the same.
Yeah, TPG.
There's no change in circumstances of the
I'll be on JJ's channel tonight at 9:30.
facts, and I use that term loosely as
Excuse me.
Giannetti was recounting for the court. Notably absent from his motion in regard to the apparent hair, which I've gone into great detail to explain. I won't bore the court with that explanation again. But what it leaves out is, again, yes, as counsel was alluding to, there were 2 items that were tested for DNA, one of which being the taillight housing. Just to be clear, the taillight that was within the defendant's vehicle, which was then compared to the DNA of the victim, Mr. O'Keefe, and that there was a significant statistical probability of comparison between Mr. O'Keefe to a number followed by 30 zeros that Mr. O'Keefe's DNA was on the taillight. The same taillight that was broken when the defendant struck Mr. O'Keefe with her vehicle. Now, as far as what counsel states as Mr. Loughran's testimony goes into great detail in the motion as well. What he leaves out, though, is that all these insinuations that the Ford Edge somehow belongs to the Alberts, or Brian Albert's Ford Edge, or something to that effect.
Every
He leaves out from that interview with Mr. Loughran, and Mr. Loughran specifically says that Ford Edge is not Brian Albert's Ford Edge. Another sort of interesting issue in relation to the affidavit from the investigator in regards to seeing that Ford Edge and his label as such is that the investigator essentially takes Mr. Loughran out to the parking lot, points to a Ford Edge, and essentially says, "Is that it?" Somewhat suggestive identification of that particular vehicle, the Commonwealth would suggest. There is simply no evidence of Trooper Proctor having a close connection with the homeowners. There is simply no evidence as far as,
I'm going to go back. I missed that. What happened?
Of comparison between Mr. O'Keefe to a number followed by 30 zeros that Mr. O'Keefe's DNA was on the taillight. The same taillight that was broken when the defendant struck Mr. O'Keefe with her vehicle. Now, as far as what counsel states as Mr. Loughran's testimony goes into a great detail in the motion as well. What he leaves out, though, is that all these insinuations that the Ford Edge somehow belongs to the Alberts, or Brian Albert's Ford Edge, or something to that effect. What he leaves out from that interview with Mr. Loughran is that Mr. Loughran specifically says that Ford Edge is not Brian Albert's Ford Edge. Another sort of interesting issue in relation to the affidavit from the investigator in regards to seeing that Ford Edge and his label as such is that the investigator essentially takes Mr. Loughran out to the parking lot, points to a Ford Edge, and essentially says, "Is that it?" Somewhat suggestive identification of that particular vehicle, the Commonwealth would suggest. There is simply no evidence of Trooper Proctor having a close connection with the homeowners. There is simply no evidence as far as, I guess now it's being positioned that he was sprinkling tiny pieces of a taillight, pieces that I described to the court earlier as less than 1/16 of an inch that were embedded within Mr. O'Keefe's clothing. I'm not going to go over again and again the issue as far as Ms. McCabe's search on her phone.
Unreal.
The court has been
I'm
provided
shaking my
numerous
head right
reports
along
from
with Turtle
forensic
Boy.
experts disputing whatever Mr. Green's findings are. Counsel seems to want to choose or pick and choose as they do with each particular piece of evidence or each report as to what they want to highlight. But the conclusions from Ms. Hyde's report are clear.
Oh shit!
That
I screwed
from
up.
her analysis of that search,
innocent.
that search was conducted respectively at 6:23 a.m. and 6:24 a.m. It is not a mystery as to when that search was conducted or why that search was conducted. It was conducted by Ms. McCabe at the bequest of the defendant. As far as anything pertaining to Ms. Reed's financial resources, again, those were filed ex parte and as the court, so I really can't speak to those.
So Karen Reed, new poll, guilty, innocent, unsure.
This case was initially arraigned in the Southern District Court. The court set a cash bail of $50,000. The defendant posted that within minutes. The defendant was then arraigned in this court.
Yeah,
set a cash bail of $100,000 initially at arraignment in June of 2022. That bail was posted within minutes. If the court is inclined to reduce the cash bail, I don't think it's of much moment to the defendant, Ms. Reed. But if it were, I would ask that some additional conditions be set in place, similar to what I had asked for previously on the February date. If the court were inclined, I would concur with surrendering a passport. I would concur with executing a waiver of rendition, and would ask that there be an additional order that the defendant be ordered to remain alcohol-free, subject to random testing with a SCRAM device, based on the nature and circumstances and based on the indictment she faces in this court. Thank you.
Okay.
If I may respond briefly to 2 points, Judge.
Okay.
Your Honor, first, with regard to the DNA being a match or a presumed match of John O'Keefe, what Mr. Lally didn't tell you is that that sample was a mixture of John O'Keefe and 2 unknown people. So I don't know if the Commonwealth is changing its theory again to say that my client struck John O'Keefe and 2 other people, and the other 2 people somehow got away. But that doesn't make a whole lot of sense. The second thing is, with regard to the Ford Edge that Brian Loughran saw outside that property, I would say 2 things. Number one, assume it was not Brian Albert's Ford Edge. It doesn't matter because there was somebody there outside the property where the body was found after 2:30 a.m. They would have either seen or not seen a body and known or not known that there was a body there. But finally, with regard to that point, Mr. Loughran was clear that it was not Brian Albert's Ford Edge. What he did not tell you, what Mr. Lally did not tell you is there's another member of the Albert family that has a Ford Edge. and that's calling out.
Okay. So, Mr. Yannetti, I need that affidavit by next Friday, so I'll take this motion
Thank you,
under
Ron.
advisement.
Appreciate it.
All right, so I said at the beginning that we need to set dates, and it's been mentioned that there have been.
I mean, there is a lot of support for Karen. There's a lot of support for Karen in this case. I mean, this looks bad. And as I'm getting deeper into this, I mean, it looks really bad. I think that this defense team is going to create a lot of reasonable doubt in a jury. This is going to be Turtle Boy already said they're already talking about filming some type of series on this already. They're actively filming it. This is going to, I'm telling you, if you are compelled about court cases, you are missing out because it just doesn't say fucking Idaho 4 in the title. You're missing out. I'm telling you. This case is gripping. It is going to be insane, and you're not going to want to miss this. I'm going to be down there because I live 20 minutes from the courthouse. I'm going to be down there during the trial. I'm going to be covering this case.
And a couple of pretrial conference dates.
Whatever I can get off in between work and go, I'm going. I will be there.
The council have not complied with the Superior Court standing order that we need to get back on track. So Superior Court standing order 2-8.
I cannot believe that people are still beating that dead drum. I literally can see it because I can see it in my analytics. What other creators everybody watches on here, they're literally still doing videos about Idaho 4. There's nothing to cover in that case right now. There's nothing to literally cover in that case right now. There's nothing to cover. And they're just making up shit. Oh, did Dylan talk to the guy on the corner in the room? Were there 4 people standing outside? Maybe there were 3. Did the guy walk by at 12 midnight and said that he saw and he heard something? This is what people are doing right now. It's crazy on Idaho 4 shit right now. It's insane. Find something else.
6. So we need to set some dates. And council has to comply with Rule 11 of the Mass Rules of Criminal Procedure regarding the pretrial
I did a video
conference.
on that today.
So I'm going to give you a date for you to fill out the pretrial conference report and do everything that you're supposed to do pursuant to Rule 11. We need that before we can go any further. And in that report, you need to outline dates for filing of motions. So I have some suggested dates, given that we were able to work out the discovery issues today. So I think all non-evidentiary motions in this case must be filed by November 16th. I don't want any more piecemeal Rule 17 motions. If there are piecemeal Rule 17 motions, you need to put in the affidavit why those weren't handled when they're supposed to be. I would like January 5th for filing all evidentiary motions. And February 15th for a pretrial hearing, final pretrial hearing. And you say that you have proposed trial dates. What are your proposed trial dates?
Your Honor, it would be the defense request, and we're open to the specific date, but we would like a trial date in March of 2024.
Okay, that's great.
Early March would be better if it's available.
So we have a trial that's starting in January, a retrial that last time took 6 weeks. So I think mid-March would be better for us.
Okay.
Jim, can you suggest dates?
Yeah, how is March 12th? 12 or 19?
So 12 would work. Is the court's preference, just going by what Mr. Riccone said, start on Tuesday?
Yes, we typically do Tuesday.
Yeah, because civil and panels on Mondays.
Makes perfect sense.
Yeah.
Does that work for the Commonwealth as well, March 12th?
March 12th, yes.
That's
So,
fine, Your Honor.
as a result of that, can we have a final pretrial conference sometime the end of February? Maybe 26, 27, 28 in that time frame? Is that,
Can you all do me a favor after this video ends? Please go up and click on that link. Just take 7.5 minutes of your time. Watch that video all the way through. Give it a thumbs up. Give it a like. I'm getting really, really low hits on it right now. The impression click-through rate is terrible. We need to get this information out about Karen. I'd really appreciate if you could watch that all the way through. I'm almost done here, and then I got a jet. I got another stream I got to get on here in a minute.
is that okay?
But I'll be back
Yeah,
tomorrow night with more Karen.
Oh,
I'm sorry. Yeah, go ahead.
It's good for me. I just want to make sure it's good for my.
Yeah.
I don't think there's much more here anymore.
Until we see about those filing of motions from January 5th.
8 or 10?
10,
12/8 is the next in-court date.
Yeah, these are just court dates. So I'm gonna pull out of this right now. Really, 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 really important and compelling stuff here. Really, I mean, this was the hearing of all hearings that you wanted to hear, if that made any sense. You know, really, really compelling stuff. I'm gonna be back tomorrow night. Listen, I just want to set this precedent here for right now. If you are questioning you're not getting any of the notifications, just come check my channel at 8 p.m. Eastern Standard Time. Next week, I'm probably going to have to bump it up to 9 p.m. Eastern Standard Time, or maybe 9:30. So check those times. If you're not getting notifications, I'm here usually every night at 8 p.m. Eastern Standard Time. Just come over and hang out. You know, if you know, I'm always here. I stream every night. I don't do anything. I don't have kids. I'm not married. Don't have a girlfriend. I go see my friends every once in a while, but you know, they all have kids. They're married. They have their lives. So, I mean, this is what I do. This is what I love to do. I love being here with all of you guys. And, you know, I'm pushing this forward because someday I want this to be my full-time job. So I will keep pushing this channel forward. Do me a favor. After the stream ends, in between, if you're going to go over and watch me on JJ's channel, take 7 minutes, 7.5 minutes, watch that video all the way through, give it a thumbs up, give it a like, give it a comment. Find me a girlfriend. No, I'm just kidding. But please find, yeah, I just almost said it again, find me a girlfriend, but please find me a girlfriend. No, please give that video a like. I really do appreciate it. And if you want to follow me on the next stream, all you got to do is wait for this one to end, and it's going to redirect you right to the next stream. You can just hit play, and it will take you into that chat room. I'll be over there for a little while tonight, hanging out with JJ and his crew. We're going to talk Anthony Farah and Timepiece Gentleman. All right, I got to get going. I want to take a little pee break before I jump on the next stream at 9:30, and I will talk to you all soon. Tomorrow night, 8 p.m. Eastern Standard Time, I'll be here. I may do a live stream during the day, a pop-up, because there were some other cases I wanted to get to, but that Tupac news broke, and that kind of screwed up my midday stream because I just went full Tupac on it. But tomorrow I may pop in and do some other true crime stories around America. But tomorrow night, I'm going to keep drilling this into everybody's head. I'm going to keep drilling this into everybody's head. You are missing out on this case. You are missing out on this case. You need to get involved. You need to understand what's going on here. All right. Thank you, lovelies. I love seeing everybody here. Thank you, gentlemen, ladies. Appreciate you all. I'm going to take off. All my mods, thank you. Thank you for all the super chats. The offline, Miss Krampus, thank you. She gave me a $19.99, and I had some other donations come in through PayPal, so I appreciate that. Yes, you got to put this out here. It's very important. And if you didn't watch this stream, it's a shame. You need to go back and rewatch it. Again, I'm going to drop that video again. Please go over, take 7 minutes. Look through that video. Tell me what you think. Leave a comment below, and I will see you all tomorrow night, 8 p.m. Eastern Standard Time. All right, everybody, I'm going to jump on the next stream. I'll talk to you soon. Bye.